All right, we're call up our third case, LineQuest versus Mondeck. Mr. Burch.
Thank you, Your Honor, and may it please the court. The exemptions found at 29 CFR Section 541 are known as the white-collar exemptions because they are limited to white-collar employees. That is, bona fide executive, administrative, or professional employees who are paid on a salary basis. My clients are blue-collar employees. That's certainly true for Garrett Nichols, who, with no prior experience whatsoever and just 2 days of in-the-field training, spent more than 95% of his working time driving a truck across West Texas and New Mexico, using an RD 7100 cable and pipe locating tool to locate and then mark the location of pipelines in response to calls to the 811 call before you dig system. It's also true for Sean Mondeck, who spent most of his non-driving time acting as what LineQuest calls a watchdog, someone to watch the backfill and cleanup crews working for folks unrelated to LineQuest or its clients who might be doing damage to the pipelines owned by LineQuest clients.
Now, help us as you go along and through the statute. Ordinarily, when someone says, quote, blue collar, we kind of have a visual image of what that may be. Somebody out there, gloves on hand, hard hat, whatever, jeans.
Yes.
I mean, literally having to get on their knees, down in the hole, blah, 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 as opposed to white collar, somebody back in the office, whatever, whatever. It doesn't strike that it's quite that line. So when you say blue collar, as you're making your argument, help us kind of understand more clearly, why that label fits versus, are they doing surveillance? Is he only in the truck? Does he have binoculars? He doesn't really get his hands dirty. Is he really just supervising other people, telling them what to do? You follow what I'm saying? So just help us understand better your notion of blue collar as related to how their duties were described and what they actually did.
Yes, and I hope to do that. Mr. Nichols, let's start with him because he's a line locator. We all know what line locators do. We've probably all seen line locators at work. A line locator has a tool, a machine known as his particular one is known as an RD 7100 that he carries out in the field while wearing a safety vest, steel toe boots, protective equipment. There's a variety of protective equipment they have to wear. And he goes around and he attempts to locate a pipeline in a field. That can require him to put clamps on various pieces of the equipment so that he can run a current through it. It can require him to open up manholes, depending on the type of line that he's doing. It can require him to climb, it definitely requires him to climb through dust and dirt so that he can locate this equipment. All of this is done in what the folks at LineQuest sometimes refer to as potentially extreme weather conditions. It's 100% outside work. For both of these gentlemen, it's 100% outside work. And for Mr. Mondeck functions as we'll get to in a second, effectively a security guard. The folks at LineQuest are going to tell you that, oh, he's out there being a construction manager. That is flatly inconsistent with the contract between LineQuest and its clients, which describe exactly what these folks are hired to do. They are hired to locate by hand, right? These are people out there using tools to locate pipelines in the field and then mark them by spray painting them. They'll have a little, looks like a stick with a can at the end of it a lot of times, where they're out there spraying, and depending on what kind of pipeline it is, these are oil and gas pipelines, so it'd be yellow. They're out there spraying, or they're putting down those little flags with the little square things that they have to push into the dirt. And that's what they do. And it's easy to understand how Garrett Nichols, with no experience whatsoever in this industry or field could be doing that job by himself in the field without supervision, quote unquote, after just 2 days of on-the-job training. Because it is a job that is rote. It's a job that you can learn quickly, and it's a job that you can perform without the exercise of independent discretion and judgment as required for exemption. Before we get too far afield, I'd just like to finish up with the fact that what we're talking about here today, of course, is LineQuest's affirmative defense of exemption. Everything that we talk about here today, they bear the burden of proof on, right? And respectfully, these are, as this court has noted repeatedly, these are inherently fact-intensive issues where a jury is entitled to decide which way it runs. Are you functioning more like a security guard, or are you functioning more like a supervisor, even though it is undisputed, or there's clear testimony in the record that they had no authority to supervise anybody, that their
district judge and the magistrate judge agreed that on the following point, not on everything, but they agreed that both of your clients were involved in non-manual work. Are you disagreeing with that?
I do disagree with it clearly with respect to Mr. Nichols, right? Mr. Nichols, his primary function, like what he spent, depending on how you want to count it, between 98 and 99% of his time, either driving a truck or out in the field locating lines, putting down flags, or using spray cans.
One of the cases they relied on is, it's a Southern District case, and with all respect to them, it's not a circuit case, so that construction oversight is non-manual work. Are you disagreeing with that point, or are you just saying this isn't construction oversight? Related, similar to construction?
Yeah. No, I agree that construction oversight it could be administrative work.
Well, I'm just starting at the category of non-manual without going all the way to the finish line of saying it's administrative.
Right. I would agree with that as well. Right. Like I would agree that construction oversight, if that's all you're doing, right? Even if it sometimes requires you to go out in the field and climb up a hill or something like that.
Quite often require you to go out and look at the construction. If that's
right. Yeah. You got to be there to do that exempt work, right? Like
So the point that at least the district judge ended up with, magistrate judge not all the way, I guess, is that both of these men were observing and not manually laboring.
So, not so for Mr. Nichols on at least 95% of his work days, right? And I'm even spotting them because they do multiple tickets during the day, right? But I'm spotting them any day where they did any of this observing work, what they call watchdog work, any of that, I'm counting that, right? But of the 158 days that he spent working out in the field, he spent no more than 8 doing any of this observing work at all, right? And again, he does multiple tickets during the day, so this is a very small percentage of his time. And with respect to Mr. Mondeck, yes, he is out there, and no, he's not using tools, but neither is a security guard, right? A mall security guard who is walking around, he's telling people not to act in an unsafe manner. He's protecting against people damaging their equipment. Recall, these are not LineQuest construction sites. They're not even the construction sites of LineQuest clients. LineQuest clients are midstream pipeline companies. They own a pipeline that's in a right-of-way. Someone else has called the 811 system and said, hey, we want to dig around your pipeline, right? And so the pipeline companies want to have somebody there sometimes when they're getting real close to it so that they can make sure that nobody dings up their pipeline, right? That's what he's there for. He's not scheduling, and this is undisputed. He's not scheduling anyone. He's not, they tell him when he has to be there to observe if he wants to observe. And he has to go there. I'm sorry, sir, did you have a question?
No, make too many facial gestures, I guess.
Right. Does he sometimes take action while he's out in the field? Yes. This is Mr. Mondeck. Sometimes he takes action. And let's look at the one example, the only example that is given with respect to Mr. Mondeck for what qualifies as his quote-unquote administrative work. It's him using his stop work authority, which literally every employee has, to stop somebody who's driving a track hoe near a live oil and gas pipeline without a mop on it. A track hoe has, you know what they look like. They have teeth on the end of the bucket that they use for excavation. A mop is like a round piece that goes on the front of it. It's to prevent the pipeline from getting dinged or punctured, even worse, and blowing up. But Mr. Mondeck said, look, that's not discretionary. I was told the rule is you must intercede if they're trying to bring something sharp around the pipeline, because the pipeline's not to be punctured. You can find the discussion of what Medallion expected of Mr. Mondeck at 315 of the record, right? And they say, we're giving you our backfilling and cleanup procedures, which is, the construction is done. We're now just covering back up the pipeline that belongs to LineQuest clients. And it tells him, if you have any question about what you are supposed to do, you're supposed to immediately contact your supervisor or us so we can let you know what to do, right? The HR manager from LineQuest, Ms. Pondo, stated, like, these folks are not supervisors, and they couldn't be, because again, it's not their crew. They don't want this construction. They're out there to protect, as the CEO. He changed positions, but the CEO at the time testified in his deposition. You're there to watch and protect the pipeline. That's your job, right? No, and mind you, Mr. Mondeck, who had never worked on a Medallion pipeline before, he started doing this watchdog job after 3 days of training, right? And before you start asking, oh, well, maybe, Mr. Mondeck and Mr. Nichols have degrees in construction management or something like that. Not so. There's no degree whatsoever required for this position, even as of today. And, I'm not sure if this is in the record or not, but Mr. Mondeck has a GED and Mr. Nichols is a high school graduate. So, with 3 and 2 days of training respectively. So the question that, as I see it, and I realize I'm already running low on time, shockingly enough, is what is these folks' primary duty? And I think the district court erred because it did not consider the character of the job as a whole. It omitted the magistrate included, but the district court omitted the relative importance of the job duties that these folks are performing, the relative freedoms from supervision, and the relationship between the salary for the wages paid to admittedly non-exempt employees. And there's an example in the blue brief about comparing Mr. Mondeck with another line locator, but let's look at just Mr. Mondeck, okay? Just Mr. Mondeck, when he was in training, when he was a trainee, they were paying him $18 an hour, okay? He gets converted to salaried exempt and loses his right to overtime and becomes a right-of-way technician. That same week, he worked something like 60 hours. And had he made $18 an hour, he would have made over $1,228 in pay. Instead, he just got $1,100. The next week, it got worse because he worked even more hours. And in his worst week, he earned the equivalent of $12.50 an hour. And I would just money doesn't answer everything. I get that. I totally get that. But I would just say that if you said, what's the likelihood that we have a construction manager on a pipeline, an oil and gas pipeline that's earning the equivalent of $12.50 an hour, it would be non-existent. Thank you.
All right, thank you, sir. Mr. Chadwick?
Morning, Your Honor. May it please the court, my name is Robert Chadwick. I represent the appellee, LineQuest. I'm going to get right to the question that was addressed by my esteemed colleague, which was the question, which is the second prong of the administrative employee test, which is non-manual work directly related to management or business operations. And both the magistrate and the district court found in favor of LineQuest on this as a matter of law that the plaintiff's primary duties were not merely oversight of excavation backfilling operations, but empowered oversight. And for this, the court looked to the contract between these customers and LineQuest. Mr. Burch mentioned one part of that contract, but the most important duties that that was contracted for with these customers, what was called site surveillance, which means, as defined in the contract, means to watch over and protect the customer's facilities. And in exchange for that hiring, LineQuest would provide indemnity for this. And so effectively, these gentlemen, Mr. Mondeck and Mr. Nichols, when they were on the job site, they were the eyes, ears, and voice of the customers. In the case of Mr. Mondeck, that customer was Medallion. In the case of Mr. Nichols, that customer was NLink. And so they were effectively managing these sites for the customers. In fact, that's what the district court below held when it said, if Mondeck had been paid simply to passively observe and not oversee the contractor's work on behalf of defendant's customers as its on-site representative, Mondeck would not have been provided any value to his employer and would have frustrated the purpose of the contract between defendant and its customer to provide site surveillance services during backfilling and excavating operations. As to Nichols, the court said, if Nichols had been merely marked lines and left during excavating activities without overseeing the work of the contractors, the purpose of the contract between LineQuest and NLink would have been defeated, and defendant would not have realized the value of employing Nichols to be NLink's on-site representative. But even beyond the language of the contract, the district court cited at length portions of the depositions of both Mr. Mondeck and Mr. Nichols, showing that this was this authority that they had that was empowered by four things. Number one, the authority provided by Medallion and NLink to them to speak on their behalf with their contractors, and in fact to stop work if necessary. And this stop work authority, understand, this is different from the stop work authority which he just mentioned, which is that.
Let me ask you this, the statute speaks in terms of primary duty, quote unquote.
Excuse me, I'm sorry.
The statute speaks to primary duty.
Right, and so the primary, so.
Hold on, let me get my question out. I mean, I hear you arguing about site surveillance and so on and so forth. My question is, counsel opposite has argued factually, what they do out there and so forth. So what is the determinant in the record of the primary duty as we're using that term? In other words, assuming arguendo, as you say, part of what they do is site surveillance in every sense of what you just argued it. But as well, they do these other things and so on and so forth. So how do we get to the primary duty? Is it quantified by the number of hours they're allocated to do it, how many days they spend doing it, that kind of thing? You understand what I'm saying? I mean, I don't think they dispute the site surveillance that you say are performed by the clients. The question is, how much of that predominates, if you will, the work out there?
Well, in the regulations and the case law, define primary duty as the most important duty performed by these employees. And the Dalheim case says that that determination is made from the perspective of the employer. So you don't do what his exercise was in terms of figuring out how many hours of the day are spent on the road driving, how many hours of the day are actually spent at the job site. The question is, what is the most important duty being performed by these employees? And in our briefing before the lower court, we had cited the Castor versus Sam's Wholesale Club case out of the Northern District of Texas, which said that a bakery manager was exempt from overtime under the administrative exemption, despite the fact that he spent 90% of his time performing the same work as hourly employees. The question was not what percentage of time he spent on non-exempt activities. The question was, what was the most important function being performed by the employee from the perspective of the employer, and in this case, the employer and the customer, which was protect this particular sites that are being excavated and backfilled and make sure that our interests are being protected. And so this is, and really what's important to think, to emphasize in terms of the unique aspects of what these folks were doing out there, and that is that they were not only speaking on behalf of Medallion and then Link with the contractors, and in fact, on a couple of occasions, stopped their work in progress because they were engaged in unsafe activities, but these folks were entrusted by the customers to be their only representative out there on the site. So, for example, with Mr. Mondeck, he was the only Medallion representative on this particular site. With Mr. Nichols, he was the only representative of NLink out on this site. And so these customers entrusted these folks to safeguard their interests when they were out there on these job sites. Also, LineQuest didn't have any supervisors out there overseeing the work being performed by Mr. Mondeck and Mr. Nichols. LineQuest trusted them to do the oversight and the empowered oversight that I'm talking about. And then finally, the enormity of the responsibility empowered by Medallion and NLink, which was risk of property damage, death or serious injury, governmental fines, environmental disaster, and the risk undertaken by LineQuest, which was indemnity of Medallion and NLink. So this empowered oversight is what distinguishes this particular case from the oil engineers in the Dewan versus MI LLC case, where those mud engineers all they did was provide advice and consultation. Rather, this type of empowered oversight that we have here is more akin to what the marine superintendents in the Xanacos versus Oil Inspections USA case. And in fact, central to the decision in Dewan was the determination that the oil engineers did not have compliance and safety responsibilities as the marine superintendents did in Xanacos. So again, these folks here had safety and compliance responsibilities. This is one of these cases where you typically, when it's the plaintiff that's arguing, oh, the title is misleading. It overstates the responsibilities. In this case, the title line locator understates the responsibilities being performed by these folks, which is in fact and truly site surveillance. In fact, Mr. Mondeck admitted during his deposition, he didn't perform any line locating responsibilities at all. He never used a tool, and so he never engaged in the traditional type of line locating that we see being performed in municipalities, like to see, before a construction dig to make sure what the line's underneath. These duties are different. This job is different, and it's more important because what they're doing is really overseeing in an empowered way the particular construction site.
Counsel, the district judge's opinion adopting in part, disagreeing in part with the magistrate judge. Quotes at length Nichols' deposition, I guess, where he refers, the deponent refers, is asked what government regulations were you following. He names a couple guidelines of government regulations. What were your responsibilities with respect to the pipeline, just to be there and see if their equipment was legal? And then the district judge, other things obviously there that you know better than I, the court finds, therefore, based on this, that he had substantial, this was Nichols, substantial responsibilities. I find the deposition testimony a little obscure. Just how much was he doing? How did he learn about these guidelines? It may have been the other party in this case who said he only had 3 days of training. I'm just wondering if that's a fair representation. Is the evidence primarily from depositions about what these people were doing out there on the ground? And was there anything more about the training? How would Nichols know what these guidelines, federal guidelines were? Were they given to him in a booklet and he was supposed to read them and apply them? Did the other party have the same sort of training?
Okay, so there was training that was provided by LineQuest in the form of on-the-job training and during which they were paid an hourly rate.
It seems to me it's fairly simple training. It lasts 3 days, at least for one of them, on the job. But he was the man on the scene. I don't know who was training him, if he was the only man out there for the company. So
yeah,
there's a mismatch between what the district judge conclusion he got from this deposition and saying these people were, at least one of them, but maybe both of them, were filled with information about what the federal requirements were and what the equipment, whether it was legal. Well, I don't see much support for that other than he said it.
He did say he was familiar with the regulations, and so that...
How would he have gotten familiar with the regulations, I guess I'm asking? Is that all we're going on, as he said it in a deposition?
That's all that's in the record. He would have gotten that from training and been provided to him by NLink in terms of what regulations he needed to be aware of.
That's an affirmative defense, burden's on you. Keep going.
Okay. All right. So, but in terms of the overall, it's still dealing with the responsibility was still management and oversight, which he did exercise on one occasion where he stopped the construction in the middle of it taking place because it was unsafe. I mean, and so district.
Isn't it true though? It's not just that he had that responsibility, and there's some argument that everybody out there perhaps should have been in a position to stop that, and you may disagree with that. But he also has the frequency of the use of the authority is relevant to whether it's his mainmost duty or not. And if he's only done it once, it doesn't seem to me it's a very significant part of his primary duty.
Well, if
isn't frequency an element of whether something is a primary duty?
No, that's why I use the word empowerment to act in that way. That's the most important aspect of the job, is the fact that when those situations come up, that we'll use Mr. Nichols as an example, that he was empowered to communicate and be the voice of NLink in discussing what needed to be done or not needed to be done.
Let me ask you this. According to 551-700, primary duty, CFR, among the factors that qualify it, factors to consider, relative importance of the exempt duties compared with other duties, the amount of time spent performing exempt duty, employees' relative freedom otherwise. So I think the amount of time that he performed, what you say is this vital responsibility, I guess another way to look at it is that he was always performing it by watching to see if anything dangerous was happening. Do you like that answer? But he didn't use his authority very much. Seems like it factors in under the regulations. If he only did it once, it's sort of hard to see that as a primary duty.
Well, I mean, if you define the primary duty as stopping it stopping a contractor from performing work, I don't think that's, the primary duty was if situations arise which present a danger to the property, danger to the people, danger to the environment, then they're supposed to act to, as set forth in the contract, protect. And this gets, and I really want to touch upon the independent discretion and judgment prong, because what the judge was focusing there on was the representative and relational nature of the job that these folks were performing. And I quote directly from the court's opinion, here the court finds that plaintiffs used independent judgment and discretion when representing LineQuest customers at a job site that involved safety work, and plaintiffs were the primary conduit of information concerning backfilling and constructing activities between LineQuest and its customers. And so in support of this conclusion was undisputed evidence. The district court found that they had stop work authority and the responsibility to stop work for safety violations over non-employees of LineQuest on behalf of LineQuest customers, with the distinction that he didn't draw, which the district court did. In fact, was exercised on one occasion by each of them. They were the first line of communication between the customer and the contractor. They had to determine how best to resolve the conflict to ensure the customer needs were being met. Neither required input nor approval when making these decisions, and that they made decisions that may have prevented death or serious injury, property damage, governmental fines, or environmental harm. Now, citing Mr. Mondeck's own deposition testimony, the district court found he performed his duties without meaningful direction from LineQuest. He performed his duties without meaningful direction from Medallion, and he was the only Medallion representative observing the excavation and backfilling operations of the contractors, and was Medallion's eyes and ears at the site. And he exercised stop work authority as the voice of Medallion as well. Citing Mr. Nichols' own deposition testimony, the district court found he was entrusted with the responsibility of being the on-site representative of LineQuest's customer, InLink, and had the authority to speak and act on its behalf with excavators and contractors. So what we have here in the case law that was cited by the district court in support of this findings deals with the situations dealing with customer relations. One of them being Pendergraph versus Fujitsu Network Communications out of the Northern District of Texas, where the court said, the court does not believe that an employment position requiring frequent interaction with customers can be rightly considered void of all discretion and independent judgment. Interacting with customers is a malleable process that requires attentiveness, reactiveness, and discerning, all of which encompass at least some discretion or independent judgment. Also cited in the court's opinion was Thomas versus Houston Metro Electric Corporation out of the Southern District of Texas, where they found independent discretion and judgment because the plaintiffs were the primary conduit of information between the company and its customer. So what the court was focusing on was the fact that, not just do they have to make a decision as to when to intervene and when to take action on behalf of the customer, whether that be Medallion or InLink, but how to interact with the contractor and how to manage that situation, how to manage the potential conflict which arises from that situation. And so that's what the court was saying was the aspect of the job which required independent discretion and judgment. And so, one of the things he's argued in his brief was, all these procedures, they may be governed in terms of, some aspects of the job, but unexpected events do occur out in the oil field, especially if there's no one around, on behalf of the customer or LineQuest. Also, you have to know how to deal with the contractors, a third party, in terms of how to handle that situation. And that type of situation clearly entails some measure of independent discretion and judgment. And that's really what distinguishes this case from the Zanikos case, which did find, similar to the facts here, that they were non-manual labor, but said no independent discretion in judgment because they really did not have authority to do anything in those cases. And the inspectors in Xenakos did not speak to the customers. They spoke to the customers, but not on behalf of the customers. And that's really the key fact here is these gentlemen were empowered to speak on behalf of customers in managing a very dangerous oil site, pipeline site. Thank you.
All right, thank you, sir. Rebuttal?
Your Honors, my colleague just told you that the most important part of the contract between LineQuest and its clients is this site surveillance. In the medallion contract, site surveillance appears exactly once. It appears in the definition section and never appears again. Contrary to what my colleague just told you, it does not appear in the indemnification section. What does appear in the indemnification section is locate services, line locating services. In addition, in the 10 paragraphs found at record site 220 through 222, the 10 paragraphs outlining what LineQuest's responsibilities are, there's not one mention of site surveillance, much less construction supervision.
Let me ask you about Nichols and what I was talking to your friend, colleague on the other side.
Yes.
About reading what the district judge quoted from Nichols' deposition. He refers to, I got to keep up with guidelines, federal guidelines. I have to keep up with whether the equipment is legal or not, which may be.
Yes.
What do we know about that other than the deposition testimony? That sounds fairly significant. Maybe not white collar out there in the field, but still may not need work gloves to do it. What do we know about where such duties come from? Why did Nichols know about guidelines, federal guidelines?
So the guidelines that they're talking about is that if there's going to be a
Sounds like a federal regulation to me. You seem to be talking about something else. Isn't he talking about federal regulations in his deposition that he had to be aware of? Maybe that's not what he meant. Nichols.
Yes. And so
How did he learn about federal regulations?
everybody knows because you have to be 12 inches from another pipeline. If you're crossing another pipeline.
Everybody knows that. Still,
What's that?
respect not the answer. I mean, he had some training to learn about these things.
Sure. Hey, it's got to be 12 inches unless the some clients say it's got to be 18 inches.
I'm just wondering how did he learn about it, and he also needed to know if the equipment was legal. Where would he know about that? That sounds advisory.
Well, you remember what we were talking about before, that there can't be anything sharp on the.
Well, again, but how, I'm not asking what the rules are. I'm asking how did he learn about them to be sent out with some package of, in his head at least, of information to apply as things occur. And you seem to try to downplay, as you should be, as much as possible what his responsibilities were. But that deposition makes them seem somewhat substantial, for which he would needed to have been trained in some way.
So my colleague on the other side asked him about some of the very specific regulations, said, hey, did you know about this regulation? Did you know about that regulation? No, I didn't. No, I didn't. No, I didn't. Right? What I did know, and this is just my take on it, but my take on it is, what he's talking about is, do you know the rules? Right? And yeah, I know the rules. The rules are that you got to be 12 inches unless the customer says more if you're going to cross a pipeline, if you're going to have a pipeline. And it is literally get out there with a measuring stick and measure, right?
My principal concern about this case is it's a summary judgment. Dewan was a summary judgment.
Right.
And some of this doesn't look to me to be a dispute about facts, at least for both of these individuals, maybe for one of them, but a dispute about what to make of those facts. What are the inferences and what is the law as applied to the facts?
Right.
Can you help me with that? Is that a characterization that you can accept?
It is a characterization I can accept, and I tell you, I feel like that ties in nicely to your question about frequency, right? Frequency matters, right? We're supposed to give these regulations a fair reading, and the regulations speak to the performance of exempt duties, right? The exercise of discretion and independent judgment, not the possession of it.
Most important. So you could have 100 things to do out there, but what is the most important thing is one of the ways primary duty is defined in 541-200, I think. I may have remembered the regulation wrong. So even if you only do it once, if it's the most important thing for you to do to make sure there's not some disaster, then I think that's relevant, even if you don't do it very often.
It is relevant, right? I mean, we didn't move for summary judgment in this case, right? Like, even though, I mean, look, I believe in my heart of hearts the guy's a line locator, for goodness sakes, right?
Hey, come on.
He is not an exempt administrative employee, right? The guy makes $12.50 an hour, right? That's a security guard's wage. It is not a construction manager's wage, right?
You're arguing it, or have, from a standpoint of there being factual disputes. And
Yeah.
to Judge Southwick's point, which is on point, I mean, the language in the statute talks about primary duty. Counsel opposite says, in response to you, quantifying these matters is irrelevant. It's through the eyes of the employer, and he says that's site surveillance. So that would seem not to matter how many hours, et cetera, they spent, whatever, if that's the case. My only question to you,
Right.
not about that, is if not do one, which Judge Southwick wrote, and which his question suggests, you know, maybe it's something different, what's your best case here in terms of the primary duty construction in this statute, in terms of these two guys? I mean, putting to the side for a moment if there is a factual dispute, but if the district court, as I understood it, ruled that they were entitled to summary judgment as a matter of law in construing the statute here. So what's the best case you have working for you that says the district court got that incorrect on the law? You understand?
I believe that I do, and I would point you to Dewan, of course. I would also point you to Xanacos, right? Because Xanacos tells us stop work authority isn't enough. They had stop work authority in Xanacos, right? And were still found not to have exercised discretion independent.
What's the best case that helps you in terms of saying to us how we view the affirmative defense, i.e. through the eyes of the employee, construing it that way? You follow what I'm saying?
I do, but recall that that's their take on Dewan, right? Like, or excuse me, not Dewan, on Dalheim, which is a case under the old regulations before we had the factors that we have now. This is from the pre-2004 regulations, right? And so I obviously don't read Dalheim the same way, but the regulation that we have now, which is 541-700, right, says very specifically what do you look at when you're trying to figure out what somebody's primary duty is, because it's way too easy to say.
Well, you cited to us in a 28J, I think a case from the First Circuit or whatever.
Yes.
I hadn't read the case, but I mean, what is it on point about? Is it the question I'm asking you, or is it a fact dispute?
I'm sorry, sir.
You filed a 28J letter
Yes.
citing to us a case from the First Circuit, I think, or some
Yes.
other circuit. And I'm just asking, how does that case help you? I mean, what is it helpful to us about, this legal question or just more about the fact dispute? That's all I'm asking.
So it said that it was a fact issue in that case, and that's all we're asking for here, right? All we're asking for is a chance to present a jury. It addressed the whether or not these folks worked, with an energy company as well, and they were performing work that is not directly related to management or general business purposes. Nobody has to know the hotline backfill procedures at a supermarket, right? That is not general business operations.
All right.
I realize my time has expired. I would like your indulgence on just one thing. We talked about the primary duty has to involve the exercise of discretion and judgment. There's been a lot of talk today about the procedures that govern this, and my colleague goes so far as to say that they can vary from these procedures. I'd just like to read you just a little bit from the president, the man who decided that these folks would be
But
exempt.
just cite it to, if it's in the record, just tell us where it is, we'll read it.
You can look at the record at 1310 to 1311. Can you think of any standards with respect to line locating or this watch and protect duty that they can vary from? Answer, no. Ms. Pondo, the HR manager, this is at 1339. Can you identify any policies that they can vary from? Answer, no.
We'll find it and look at it. You're right. I mean, you've pointed it out.
I do.
We'll find it and read it rather than you reading it to us.
I appreciate your indulgence, sir.
All right, no worries. Thank you both sides for briefing and arguing the case. The case will be submitted.
Thank you very much.
Thank you.